Hi, and thank you for joining me here on YouTube. My name is Will Hannosh. I am an attorney here in San Diego, California. I've been practicing since August 2007, so 16 years now. I practice mainly in the areas of family law and elder abuse litigation for the plaintiff's victims. My office is right here in the heart of Mission Valley, and today I wanted to talk about an important topic. I want to talk about Minors Counsel, and I want to explain what Minors Counsel is. In every county in the state of California, there is a panel or a list of attorneys who are ready and willing to serve as counsel or attorneys for minor children. This is obviously going to appear or take place in family court and in juvenile court. I have served as minors counsel in many cases here in the San Diego Superior Court system. And so I want to talk about I want to give some background information, some basic terms to explain what minors counsel is and how the appointment of minors counsel can affect a custody visitation case. First off, I want to talk about how minors counsel is appointed onto a case. Minors counsel is appointed onto a case by court order. So normally courts will appoint minors counsel or counsel for the child or children if there's more than one child subject to the custody visitation dispute. They'll appoint the minors counsel by court order. And the name of that court order is Order Appointing Counsel for a Child. And so if you want to find out what minors counsel specific task or responsibility is, you look to that court's order, and that will tell you. Now, as you may know, our family courts in California are inundated, they are overwhelmed, they are overworked, and they are taxed. Family court judges have a very demanding and difficult schedule, and they have a lot on their plate. Why am I saying that? Well, because sometimes when a court issues that order appointing counsel for a child, they'll just write as to why counsel is being appointed for the child. They're just going to write the words high conflict custody case. As minors counsel, I'll admit I'd like to have a little bit more direction than that. It is nice to see a very specific or narrowly tailored task or responsibility for minors counsel when I'm appointed onto these cases. And so I would appreciate that kind of specific definition, but sometimes we don't get it. Sometimes, truth be told, the courts are just so inundated with so much that's going on in even one case from an evidentiary standpoint. So they need an attorney to come in to act as a fact finder. Most of the cases, from my experience, most of the cases require a minors counsel to be appointed because they're just simply too high conflict. The parents are not only not cooperating with each other for co-parenting purposes, they're not even attempting to. And unfortunately, one or both parents are basically putting gasoline on the fire, so to speak. So that's one reason why a family court would appoint minors counsel onto the case. Obviously, there are other reasons too. It could be there are allegations or accusations of abuse or neglect of the child, or some other dynamic that's calling into question whether that child's continued custody or care by one parent is in the best interests of the child or children, if there's more than one child in the case. So there could be various grounds for why court would appoint minors counsel onto a custody visitation matter. But in a nutshell, it's always going to have to do with the best interests of the child. Now, I will say that when I am coming onto a minors counsel case, let's say I received that court order that appoints me, it may have a specific task or responsibility that I need to fulfill, or sometimes the court just says high conflict, and that tells me a lot. And so when I get onto the case, I do take my job very seriously. I know that I'm being called to do an honest and reasonable and comprehensive inquiry into that case. There may be a lot of different moving parts. I understand that the court, family court or family court services, the FCS office, I understand that they may not have the time or the resources to look into everything that's going on. They may not be able to interview third-party contacts, either witnesses or third-party collateral contacts. They may not be able to speak to that CPS social worker. That's where I would come in. If there's witnesses who are relevant and precipient witnesses, I'm definitely going to interview them. Normally, as a matter of practice or protocol, I represent the child or children, so I'm going to interview my client, the child or children, before I interview anyone else. I usually interview the child first, and then after I've taken in or digested what they need to tell me, then I'll interview the parents. And then I usually move on to other contacts, be it CPS social worker or sports team coach or teacher or school counselor or school nurse and what have you. So minors counsel, make no mistake about it, is an attorney for the child, and what that means is, as an attorney, I am taking my duties to the child client just as seriously as I would take them toward any other adult client. I have the duty to zealously advocate for the child. I have a duty to represent them competently. I also have a duty to keep them informed. So now, if the child is of age where they can communicate, they're able to give and take, they're able to understand my role in the case and what I'm doing, then obviously I'm going to keep my child, the child client, updated and informed about what I'm doing on their behalf in court. Now, obviously, there are cases where I may be representing a 1 or 2 year old child, and that's a dynamic that you just live with and do the best you can as minors counsel. So that is what an attorney is, acting in the capacity of minors counsel. They have all the duties, all the responsibilities that any attorney would have for any client. What I want to talk about also is what minors counsel is not. Definitely want to make it clear that minors counsel is not a backup attorney for either of the parents. Minors counsel is not someone that either parent should try to nonchalantly or lackadaisically turn to in order to get either generalized or specific legal advice for their case. That's not why we're serving on the case. We're serving on the case because, in a nutshell, we want to determine what is the best interest of that child, and we are appointed onto the case in order to make that determination by interviewing the child, if possible, and interviewing everyone else. When I get a case, to be quite honest with you, I look at myself not just as an attorney, but as an investigative journalist who's been called to turn over every single stone. And that's what I do when I receive a minors counsel appointment. I want to talk about how minors counsel's involvement can affect the case, how they can affect the outcome of a case. I will say courts are giving great deference to the minors counsel's opinion or position because regardless of the bases or the grounds for why minors counsel is being appointed, court is saying, hey, I need help from an evidentiary standpoint to know what the heck is going on out there in the field, and you, minors counsel, have that ability and freedom and authority to look into that and give me feedback. Now, what I usually file with the court is either a trial brief, oftentimes I'll call it minors counsel position statement, and I am a neutral. I am a neutral in the sense of I am providing the facts and my findings as to what I'm perceiving in the case, but I'm definitely taking an advocacy position on behalf of my client, the child or the children. So make no mistake about it, family courts and juvenile courts give great deference to a minor's counsel's position on behalf of that child client, and many times their rulings, their orders, weigh or are given based on what minors counsel is telling them or informing them about. So that's something that if you're a litigant in a custody visitation case, you want to keep that in mind. You especially want to keep that in mind when you're talking about the other parent. You want to keep that in mind in regards to how you conduct yourself in court. You want to keep that in mind as to how you are presenting your case in chief, because if you are a parent or a litigant in a custody visitation matter, minors counsel is most likely going to want to speak with you and interview you, and so you want to give minors counsel the best face that you can. So moving on, I just want to talk about who pays for minors counsel, and the court will either order both parents to pay for minors counsel, or the court may order the county to pay minors counsel fees. So the County of San Diego recently increased minors counsel fees to $100. That took place on September 1st of 2022. That went up from the previous $60 per hour. So make no mistake about it, minors counsel or attorneys who are representing children are not becoming wealthy or getting rich off of taking these cases. We do it because it is a public service to the court system and to the public at large. And I do it because I simply love representing children in court. It is the most satisfying part of practicing law, and I always relish and get excited over being appointed as minors counsel in custody visitation matters. So if you want to talk to me about any other issue, or you'd like to come in for a consult, if it has to do with family law or elder abuse, either or, feel free to call me. My information is down there. My email and phone number are there. Again, I'm in the Mission Valley area, and if you mention this video, you have to mention that you saw me on YouTube. And that way I can give you your free 30-minute consultation. So thank you for hearing me out. It was great talking to you about this topic, and I'll see you on the next video. Have a great day. Bye.